Greetings and compliments of the new year.
Can you remember any other project in the country that has engaged the legal fraternity to this extent?
Well, what comes immediately to mind is the Truth and Reconciliation Commission, and precisely because of the emotive past and the emotions that it invoked. And it was an elaborate process, and it took quite a substantial amount of time. So after that, what comes to mind is indeed the State Capture Commission headed by Deputy Chief Justice Zondo.
Yeah. And just what kind of conversations were taking place in the legal fraternity? Because there were times when it seemed like the commission had the ability to be divisive in the fraternity.
Look, if you have 10 lawyers in one room, you'll get 10 different interpretations on the same set of facts. So it came as no surprise that it would elicit different responses. And lawyers are exactly that. They ply their trade in being legal smiths. They have at the forefront of their mandate to protect the interests of their clients. Depending on which rose-colored glasses you're looking at it from, lawyers would do the best they can, even to get the most of guilty people out of a pickle. But I think what was interesting about this process was that it was primarily an inquisitorial process, which also afforded those who may be implicated an opportunity to confront their accusers on application to the chairman. And I must say that one of the sticking points would be in future that not all those who were implicated, who have also availed themselves to the right available, namely to cross-examine their accusers, were afforded that opportunity for reasons I cannot really go into now. And that, I suppose, could have the potential of muddying what would otherwise have been an excellent project. But other than that, it ran exactly along the lines of any other commission of inquiry that I may know of or that I may have been involved in.
Before we go into some of the specifics of the report, let's just go back to that interdict by NPO Democracy in Action yesterday, which of course didn't succeed at the courts. What are your thoughts about that effort?
I predicted on other platforms that it was, quite frankly, and no disrespect intended, it was stillborn. Firstly, they would have had to cross over the hurdle of urgency, because it has always been known that the report at some point would have to be handed to the sitting president. And as a matter of fact, this report should have been handed in months ago. And the question then would have been what steps were taken back then to try and raise the legal issues that they were raising on the eve of the application being heard. But most importantly, it was of academic value because when the application was launched, the president had already received the electronic version. What was happening yesterday was a ceremonial handing over. And I think for that and many other reasons, it was a no-brainer that it wasn't going to succeed. The fact that the report is handed over to someone about whom there are some concerns, it is an issue that could easily be dealt with, or that should have been dealt with as and when that reality came to your knowledge as the would-be applicant. I'm not going into the merits of whether or not the issues that they are raising legally are weighty enough. It may well be so that could be the case. But from an agency point of view, I'm not surprised that it didn't see light of day.
So just in terms of the content and the veracity of the report, the Deputy Chief Justice, who's now the Acting Chief Justice, was supposed to determine whether the evidence laid before him established state capture. And he says that the Commission has concluded that state capture has been established. Your thoughts on this?
Well, I don't want to purport to be in the mind of the DCJ, but I am unsurprised that he would have come to that finding. We, as ordinary citizens, followed the proceedings there. And I think he cannot be faulted, in my personal view, for the finding and the conclusion that he has reached. Obviously, one has to be circumspect in engaging more deeper on that because he himself is yet to release the reasoning that underpinned his findings. And he said that will be contained in part 3, which is sensible. But I think the cardinal point that he had to determine, he has determined whether we agree with him or not, that there was state capture. He then has to explain the reasoning, which we will only understand once he has, finished all the installments. But I think the cardinal question, he has determined definitively that there was state capture. Presumably what has to happen is consequence management arising from that. He has also released the initial salvo of the recommendations. And I think it will only be fair for anyone to engage with the report properly once the full report itself, including the reasoning, has been made available. Because at the end of the day, those who are aggrieved by the report would undoubtedly take it on review, but they cannot take the reasoning on review. It's got to be the findings underpinned by the reasoning so that you understand how he arrived at it, because at the end of the day, it's going to be based on whether or not did the decision that he arrived at, was it rational, was it substantiated by the objective facts before him. But I can assure you that it's not a matter that is going to die down anytime soon. It will definitely be taken on review on a number of bases.
Will this then result in a prolonged process that probably, and one of the concerns here is, can the NPA act swiftly on the report? Do you think this will be a protracted process?
The review of the report itself will definitely be protracted, but I cannot see how other law enforcement agencies could be precluded from using the objective evidence that is before them to make their own independent decisions. For example, the NPA does not need to be told by Deputy Chief Justice Zondo or anybody for that matter on whether or not to prosecute. They review the material before them, and then they themselves make an independent call whether or not to prosecute. And once they make that call, then they follow it through. It may well be that, notwithstanding the recommendations, they may take the view independently that on the basis of what we as NPA have, we are not prepared to proceed with the prosecution, or they may want to investigate further so that when they do make the decision to prosecute, they do so on the basis that they have a solid and reasonably winnable case. It does not necessarily follow that they will do as the DCJ has ordained. The DCJ will make recommendations, and recommendations are exactly that. They may either be accepted or rejected, but obviously those are not decisions that would be taken lightly.
Of course, the President yesterday, in accepting the report, committed to taking the report to Parliament and his responses to it. But I just want to ask you if there are any underlying principles within the law that actually compel the President to act on the recommendations of Deputy Chief Justice Zondo.
He has, by acting on the recommendations, one must read application of his own mind. He is not expected to follow it blindly. It may well be that there may be certain recommendations that he feels or that he may be advised are not capable of being implemented in the manner in which they may be fashioned. But what the President cannot do is to completely ignore the recommendations. He has to engage with the recommendations. He has to give reasons why he would elect to act in this manner or that particular manner. So it is not open to him to simply say, look, there are recommendations, I'm not doing them, and therefore I'm not going to do anything about it. In fact, we live in a constitutional democracy, and that is why he's also enjoined to take it before Parliament. And I think from the President's statement, he is planning on doing that on or about June, which is correct, because from the final installment received end of February as predicted, he would need time to carefully consider it. The first part was 874 pages. The total volume of paperwork and pages that need to be considered or that were considered by the commissioners, just north of 8 million pages. I'm not suggesting that the President is going to go through 8 million documents, but there are weighty issues being raised. There are some recommendations that will have an impact on proposing remedial legislation. There are suggestions that certain agencies would have to be formed. Now, all of these things are not necessarily posing in the province of the President alone. He would need concurrence, Parliament has to kick in, and other stakeholders must be consulted. Hence the lead time of about 3 to 4 months to enable him to tell South Africans and Parliament that having engaged with the recommendations, these are the steps that I intend to put in place to to follow through and to implement. So I don't think that it is unreasonable. It is logical, it is sensible. But whether or not prosecutions per se will follow from this report is something that we should not necessarily link to the report per se. The report can only strengthen that. I think it depends on the political will of the NPA and the extent to which the evidence that was received by the commission may or may not have been contaminated. There may well be other issues that may be raised, but I do not think that the NPA necessarily has its hands tied until the legal process are finalized. The review is going to take years. This matter is going to be with us for years to come, but consequence management can still happen unless it is interdicted by those who are aggrieved and affected by whatever is being proposed as a recommendation or remedial action.
You said at the beginning of our conversation, although you would not be drawn into detail, that your concerns about transparency of the process and also a bit of concern that others never got a chance to cross-examine their accusers. As a practicing legal practitioner, you yourself engaged with the commission. For instance, you dealt with the issue of the suspended Deputy National Director of Public Prosecutions, Nomgcobo Jiba, and her appearance there. What were your own personal engagements with the commission, and what were your takeaways?
Firstly, I must say right from the outset that I found the commission to have been very cordial, professional, and collegial. We might have butted heads, but I would be disingenuous if I suggest that I, on behalf of whoever I might have been representing, was not given a fair opportunity to do what I have to do to protect my client's rights. It was a very difficult process, emotional at times, but there were real issues that had to be grappled with. For my part, I am satisfied that I acquitted myself well in representing those that I was acting on behalf of, because the environment was conducive for that. And we approach matters differently. We give different advices to clients. Sometimes clients accept your advice, sometimes they don't, and that's all you can do. But for my part, I cannot say anything where I am involved stands out as something that would be a travesty at the instance of my clients. I represented former Minister Dipuo Peters. I went there on at least 3 occasions, and we engaged robustly with the issues. And at some point, I differed with the chair on what ought to happen. And in the case of Advocate Jiba as well, the chair indicated that he was minded to rule against me. After 17 minutes of persuasion, he changed his mind and we found each other halfway. And I'm sure other practitioners as well had the same exercise. I cannot speak for those who elected not to take the opportunity, because it becomes difficult to now look outside and start throwing stones into the tent when you had an opportunity to engage. Whether or not your submissions would eventually hold the day is something else. But I, for one, as you asking for my personal view, I am satisfied that I gave the correct advice to say, let's go in there, engage. And having read the preliminary report, the first one that, not the preliminary report, I beg your pardon, the first report, part 1, in reference to the client that I represented there, I am satisfied that my submissions were taken into account, and that is why there are no adverse findings against the person that I personally represented. Of course, the process was not a model of clarity. There could have been other loopholes there, but by and large, at the procedural level, I personally cannot fault it, and I'm speaking as an officer of the court and a fairly senior legal practitioner. I think I would give it 90% in terms of my own approval. I comment no further about the substantive correctness of the findings and whatever the resultant, remedial action. But I think the process on the whole was somewhat fair and open and transparent. And whatever the shortcomings may be, those are issues that the review court might have to grapple with. But I think on the whole, the DCJ and his team did well. And it's now a chapter that they must close and let other appellate processes or review courts interrogate the correctness of their approaches. And they may well be found wanting or not. I don't know. It's not a call that I can make at this stage.
Yeah. So this part 1 with this 3 volumes focused on SAA, on the new age, which then by extension means the Gupta family, and then the South African Revenue Services and public procurement. Just in terms of what you've seen, your initial thoughts, are the findings thorough enough, and what do you think of the recommendations?
I think, firstly, the findings are well merited. The recommendations are well thought through, and they are sensible in my view. It's the implementation thereof that may be a bit of a challenge, because it's not a process that the DCJ has control over. Once he submits a final report by the end of February, he is functus. He no longer has authority over this. It is up to relevant functionaries, up to the president, and it's up to other stakeholders who will have a direct impact or influence on the processes going forward. Because remember, the president can't just stand up and pontificate and say, I'm going to promulgate an anti-corruption charter, I'm going to form this other agency. There are legal functional processes that have to be followed to see to it that those recommendations, upon being accepted, are being filtered through. So I think the devil is more in the implementation part of the recommendations. The recommendations themselves, in my view, are sensible and carefully considered. And I think kudos to the DCJ there.
The former public protector says that the handover and the release of this report are a game changer for the country. Do you have the same thoughts?
Look, I think that's atmosphere. I wouldn't describe it along those lines. It is a legal process. It has run its course. It's not a new process. So there's no game, in my view, that is being changed. It's simply following through on the legal instruments that are being that have always been there on the table. This didn't come as a result of any new law, and that's where I part ways with my decent colleague, my dear sister, Advocate Madonsela. I wouldn't describe it in those flowery terms, but of course, it is a good and defining moment in our jurisprudential journey, because at the end of the day, the question should be, arising out of this exercise, how is it that society's approach to this type of matters is going to be changed? And for that to happen, you need a multidisciplinary approach. You need the NPA, you need law enforcement agencies, but you need ourselves as ordinary citizens to say, now that we know how easy it is for some of these things to happen, what do we as a society do to also try and make sure that there is never a repeat of these things? They were systemic, they were endemic, but they were engineered by human beings. So we should also deal with the moral consciousness of ourselves as individuals. And ascribing to it flowery language, in my view, doesn't really add any utility to the real issue. But I have absolute respect for the characterization by Advocate Madonsela of how she sees it. I'm just being a lawyer, hard, stone cold, facts-driven, apply the law to the facts, or the facts to the law, and that's it, and bring no emotion to it. But I can understand where she is coming from, but I don't share that description.
Advocate Zola Majavu, thank you so much for your time this morning. We could speak forever, but time constraints exist. But thank you so much for your time this morning. Advocate Zola Majavu is a senior lawyer giving us his initial thoughts about that report that came out yesterday, and his final thoughts in this conversation relate to our question of the day, where we're asking, will the handover and release of this report effect change in South Africa?